Tax Preferences. I hope I can make it through this. As I was joking with somebody the other day, being in the pandemic so long, I now have the social skills of a petulant teenager, apparently. So, you know, cross your fingers I can get through this all right. So with that, one of the first things we need to do is we need to take a roll call of commissioners, which I will conduct. Now, just as a point of change going forward, though, we have quite a bit of voting to do today, and I have asked actually Marilyn to handle the call of the vote this time around. But to start with, I will handle the roll call just to see officially who's present today. So when I call your name, please respond by saying here or present. Ronald Buing.
Here.
Diane Dick.
Here.
Sharon Kyoko.
Here.
Andy Meadows.
Here.
Okay, I'm the chair, Grant Forsyth, here. Also, just for the record, we have two non-voting members, Senator Mark Mullet. Okay, does not appear to be present, and State Auditor Pat McCarthy. Okay, also not present. Okay. All right, before we start the official business, just a couple of issues here. Anyone wishing to provide public testimony can provide written comments to jlark@ledge.wa.gov or in writing to P.O. Box 40910, Olympia, Washington, 98504. Or you can go to the JLARC website or the commission website and get the contact information to submit any testimony. Okay. Also, we do have staff from the Department of Revenue that are available today for any questions. So with that, let's go right into the committee business. The first issue was something I think we normally would have done at the last meeting last year, but we're going to go ahead and do it at the beginning of this meeting, and that is set up the commission chair and vice chair elections. Okay? And we're going to start with the chair, and so the chair will call for nominations for the election of chair, and I would like to say that I'm willing to do it again if somebody's willing to nominate me.
As Ron Buing, I will nominate Grant Forsyth for chairman.
Do we have a second?
Second.
Okay. Do we have anybody else who would like to run for chair? Okay. Seeing none, then we'll go ahead and ask JLARC staff to conduct a roll call of the votes with me running as chair.
Okay, this is a roll call vote to elect the chair for the Citizen Commission for Performance Measurements of Tax Preferences. And the nominee for the chair position is Grant Forsyth. Please indicate your vote by saying aye, A or nay as I call your name. Ron Buing.
Aye.
Diane Lords-Dick.
A.
Grant Forsyth.
Yay.
Sharon Kyoko.
A.
And Andy Knopfsinger Meadows.
A.
Thank you. The ayes have it, and there are five ayes and no nays.
All right, thank you for your confidence. So let's go ahead and move to the vice chair. So the chair will now call nominations for the election of vice chair. And do we have anybody interested in running for vice chair?
I'll throw my hat in the ring.
Okay. Well, I would like to nominate my part Ron Buing for vice chair. Do we have anybody else who's interested? All right, with that, JLARC staff can now conduct the vote.
Okay, this is a roll call vote to elect the vice chair of the Citizen Commission for Performance Measurements of Tax Preferences. The nominee for the vice chair is Ron Buing. Please indicate your vote saying A or nay, and we as I call your name. Ron Buing,
A.
Diane Lords Dick,
A.
Grant Forsythe,
Aye.
Sharon Kyoko,
A.
Andy Knopfinger Meadows.
Aye.
Thank you. There are 5 ayes and 0 nays. The ayes have it.
Okay. Thank you very much. Thank you, Ron, for your willingness to do that. All right, so that gets us through the election part of this. The next issue would actually normally have been with Stacia Holler, complying with public meetings and public records. And we've all heard this. I asked that she come every year to give this presentation, just so we're all clear on what the rules are, because they are somewhat complicated in Washington State. But she's currently at another meeting, so we're going to move this to a later period and let staff move on to the next issue they wish to discuss. So Keenan?
And if I might, Chair Forsythe, I think we want to approve the October meeting minutes before we get to the agenda.
Yes. Yes, I apologize. I missed that. So before we step forward with that, there's the October 21st, 2020 meeting minutes. Is there any comments about those minutes from commissioners?
Move to approve.
Okay. Second. And so with that, can the JLARC staff please conduct the roll call vote on the minute meetings?
Yes, of course. This is a roll call vote to approve the October 21st, 2021 Citizen Commission meeting minutes. Ron Buing,
Aye.
Diane Lords Dick,
Aye.
Grant Forsythe,
Aye.
Sharon Kyoko,
Aye.
Andy Knopfinger Meadows.
Aye.
Thank you. The ayes have it.
Okay. Good. Thank you. And thank you, Keenan, for bringing that up. And so again, the next item would normally have been Stacia Holler, but we'll keep her till a little bit later. So Keenan, I will ask you to move to the next item staff would like to discuss in place of that.
Thank you, Mr. Chair, and welcome to all the commissioners and to the public watching today. We've got a few things on the briefing items on the agenda today for all of you. One bit of administrative information before we move on to more of the content. If the staff could pull open the 2021 meeting schedule, we just want to remind everybody of the dates we have forthcoming, and then it's also a good reminder of the topics that we'll be discussing on those days. So you'll see there on the screen, we've got today's meeting related to the 10-year review schedule and discussion of the expedited reviews. August 3rd is when we'll kind of start the big order of business for the year, which is you'll hear the JLARC staff present the 2021 full reviews. Then September 9th is our meeting dedicated to public testimony. And of course, at this point, we're anticipating it's still going to be potentially via video conference, but we're keeping the possibility that if things shift, we may have a different venue, but we'll just need to be able to react and see how things progress in terms of the public health issues. And then October 20th would be the dates where we would have you be wrapping up for the year, adopting your comments on the reviews, and then being able to transmit that information on to the legislature. So one of the things I just wanted to, with the chair's dispensation, just be able to double check with all the commissioners that they don't have any concerns about those dates. If we have any conflicts, if we know about them now, we obviously got a little bit of time that we could explore shifting some of them.
So commissioners, any issues with those dates whatsoever? Okay, that's great.
Well, great. With that, and unless there are any other questions about the focus of the upcoming meetings, and I'm not seeing any commissioners raising their hands, so I think we could move on to the next part of the agenda, if that's okay, Chair Forsythe.
Please do.
Okay, let's move to the 2021 legislative session updates. And we have two parts of this. Dana Lynn's going to start off about talking about one particular tax preference that we actually reviewed a little early this year in order to bring it to the legislature in advance of the session because there was a kind of time-sensitive issue that she'll discuss in a moment. And then Eric Thomas and Rachel Murata are going to go over general overview of some other bills that passed related to all the tax preferences that are kind of underway. So, Dana, could you start off?
Apologies, we swapped up on you. We were going to start with the overview and then move to Dana. Sorry about
Okay.
that.
Great, no problem.
All right. Good morning, Chair Forsyth, members of the commission. Eric Thomas, staff to JLARC. With me are my colleagues, Dana Lynn and Rachel Murata, to discuss tax-related legislation from the 2021 legislative session. Very quickly pull the Okay, so hopefully you can see the summary of legislative actions regarding tax preferences.
It's not showing up yet, Eric. There we go.
Okay. This year, the legislature implemented 4 of the legislative auditor's recommendations and 1 of the citizen commissions. Dana will discuss the implementation of a recommendation from a targeted urban construction review, which, as Keenan mentioned, you were originally scheduled to hear in August of this year, but was instead expedited to December to provide the legislature with the opportunity to act this past session. She will discuss that in more detail shortly. And Rachel will discuss legislation related to the multifamily property tax exemption preference, which you may recall we presented to you in 2019 and had legislation in 2020 and was further implemented in 2021. I very briefly want to touch on 3 recommendations that were implemented. House Bill 1296 implements the recommendation of the Behavioral Health Administration organization review from 2018 by continuing that preference and adding a performance statement. Senate Bill 5396 implements the recommendation of a 2020 review on farm worker housing that you heard last August. This bill aligns the definition of farm worker with other housing programs that are administered by the state. And finally, the legislature implemented the Citizen Commission's recommendation on the customized workforce training program. You'll recall that the legislative auditor recommended terminating that preference, and based on public testimony, you recommended extending the preference, but with a different intent focused on recruiting, retaining, and expanding existing businesses, which is exactly what the legislature did. We also in this table have included this is a preliminary summary of tax-related legislation for you. There are 15 new preferences, 8 of which have performance statements, and 7 of which the legislature exempted from the requirement. We are happy to discuss any of these preferences with you if you have any questions. Otherwise, I will hand it off to Dana to talk about the targeted urban construction preference.
Just real quick, this is the chair. So what were the ones that received exemptions?
So those are the ones that are in the right-hand corner. The provisions of 82, 32, 805, and 808 do not apply. Mm-hmm. So that was related to grants issued during the COVID-19 emergency. Mm-hmm. Medical expenses, liquor license privileges, a B&O tax deduction on auto dealers, the capital gains tax, and salmon recovery grants.
Okay. Thank you. Any other questions from commissioners on that? Okay, Eric.
Hello, everyone. This is Dana Lynn. Can you see my screen?
Not quite.
The share screen option doesn't seem to be cooperating today.
You were right, Dana, to be suspicious about your optimism at the beginning.
Even when it works great in the practice round. Even then. Yeah, I'm hitting share screen and nothing is happening. It doesn't look like. There
There we go.
Okay, Geneva is going to run it, so sorry about, there may be a little bit of weird hitching along the way. Anyway, it's great to see you all. Thank you, Chair Forsyth. I'm Dana Lynn, staff of the committee. And as Eric and Keenan both alluded to, we are going to give you a little taste of what you'll have in July early today with a review of our preliminary report on the targeted urban area property tax exemption. This particular report didn't follow the normal trajectory for our tax work. When we started doing our research and preliminary investigations last fall, we ran into a number of issues that we felt the legislature would want to hear about earlier rather than later. So we did expedite the production of the report and did present it to the JLARC committee at their January 2021 meeting prior to session beginning. In the meantime, in the last few months, there have been some changes that have happened that we'll update you on as well. So with that, I will just get started. This is a local property tax exemption for targeted urban areas. It was initially enacted in 2015 by the legislature, and under current law is scheduled to expire December 31st, 2022. And there are no savings during the current biennium. The legislative auditor concluded, Geneva, thank you. One more. That cities may be ineligible to offer the preference and that legislative action is needed if the legislature wants to ensure the preference is available in the future. So this, as I noted, is a local property tax exemption. Next slide, please. That means that the state property tax is not impacted by this particular tax preference. It only applies to those cities that enact it, and counties can enact it as well. The property tax exemption was intended, specifically stated to be intended to encourage new industrial and manufacturing development and create jobs in specific areas. And the legislature was very particular in how they established this. They did specifically limited in statute to be available only in cities, in counties with a population between 700,000 and 800,000. Click, please. This was only Snohomish County in 2015. In addition, the tax preference could only be available in cities that had a population of at least 18,000 and were located either north or east of the county's largest city. Snohomish County's largest city is Everett. So that's specifically limited this tax preference to only the cities of Arlington, Marysville, and Lake Stevens. Next slide, please. In 2015, this was passed, and by 2016, the specific tax preference had been enacted as an ordinance in the 3 cities. As you see, they also did set aside specific targeted areas where there was either underdeveloped or undeveloped land that was zoned as industrial or manufacturing. They specifically wanted to attract businesses to those areas. However, what we found when we looked into this is that it's unclear if any cities actually can offer the preference. And that's because Snohomish County, next click please, exceeded the 800,000 population limit in 2018. Next click. The Department of Revenue, when we reached out to them to get their read on how this would impact use of the tax preference, the Department of Revenue did state that no city has been eligible to use this since Snohomish County exceeded that 800,000 population limit in 2018. After getting the Department of Revenue's policy statement, we did reach out to the 3 cities as well. The cities disagreed with the department's position. Next slide. The legislative auditor recommended that the legislature review and consider whether to extend this tax preference. I noted that if the legislature wants the preference to be available for future use, it should modify the preference's population criteria and also determine an expiration date for any new participants to the program. And we do note, again, the Department of Revenue and the cities disagreed as to whether the cities were even eligible to offer the preference. We do have late breaking information. News flash, the legislature did act on this in the 2021 session. Next slide, please. They passed engrossed House Bill 1386 in response to the legislative auditor's recommendation. That bill was delivered to the governor on April the 26th. I checked this morning and nothing has happened yet, but we'll continue to check on that. I'll share with you a few of the highlights of the legislation. It did a number of things. First of all, it did remove population limits completely from the program. That means now that any city or town in any county would be able to enact an ordinance and offer this specific local property tax exemption. It also extended the expiration date from 2022, the end of 2022, to December 31st of 2030. This tax preference has a number of requirements of the businesses that can apply for it. And the new legislation also made some changes to those particulars. One that we wanted to point out was that previously the minimum wage that was required for any new jobs that were created by the companies, and they are required to create 25 new jobs with these construction projects. The previous minimum wage was $18 an hour minimum. That has been raised in the bill to $23 an hour minimum, and those new jobs must provide health insurance for the employees. And one more thing we wanted to highlight is that the tax preference previously was limited to just manufacturing businesses that have a specific NAICS code. This new legislation expands the qualifying businesses to include transportation businesses as well. However, the cities can choose whether to include or not include transportation businesses to qualify for the tax preference. In addition, the legislation does seek to have certain types of businesses be preferred for this preference, including those owned by minority, women, or veterans, and also seeks to have apprenticeship programs be utilized by the businesses, among other things. Next slide, please. So our next step will be to give a quick update to the legislature at our July meeting, along with all the other preliminary reports for 2021. And then we'll be back to the legislature in December of 2021 with the final. The full report is available on our website, along with a one-page review. Here's our contact information for our study team, and we'd be happy to answer any other questions you might have.
Well, this is the chair. I have just a couple of questions and a comment. I'll start with a comment. So staff did contact me about this, that they were going to have to do this research a bit early. So I was informed about it. Like any good chair, I fussed. I said, well, why do we have to do this? But they did point out that the legislature really was going to need to modify this bill, and it was better to do it with the research in front of them. And so I really concurred ultimately with staff. It was a good idea to just move forward. So the legislature really did have good information as they reconsidered this bill. A couple questions about the bill. One is that's a pretty far out expiration date, 12/31, maybe longer than what we're used to seeing. Was there some thinking behind that?
Well, it's 12/31/30, so it's what, 9 years ahead. I
Mhm.
do not know for sure I know in one of the original bills, it was bill versions, it was 2026. And the
Oh.
ultimate version that did pass, it would send it out to 2030. I don't really know, Grant. I do know one thing I can bring up, and one reason for this
Mhm.
problem that happened with the population issue was that the 3 cities in Snohomish County that did pass the ordinances, they also were working to create a specific kind of zone, and the name of it is escaping me, but it's a special type of zone that has special transportation infrastructure monies that come to it through the federal government, and it also receives a lot of press and some outreach that is done by the Department of Commerce. And those cities really wanted to get that type of designation for those targeted areas. That took a lot longer than they had anticipated. And I think they weren't really thinking of the population issue. They were just worried about that other thing. By the time they got the designation, it was 2019. And so that is what happened. So they sought more time as well to be able to now market these particular programs. They've got their designation in place and they're ready.
Okay. Yeah, that makes sense. If a lot of what they're going to plan is long-term, then you probably don't want the expiration date in a couple of years. Were these like empowerment zones before? Was that what they were? I mean,
there is a few of them are within opportunity zones. I think some of the ones in Snohomish County, who knows where the other ones might be. They certainly might be joint type of where they are opportunity zones, and others they do need to be designated specifically as industrial or manufacturing to apply for this as well. So there are quite a few different designations. I did want to state too, this is a 10-year property tax exemption for these businesses. So after the 10th year, they will be subject to local property taxes at that time.
the other, it's probably more of an observation, but maybe it's partially a question too. It seems like they actually significantly rewrote this bill, so it doesn't really look too much like the original one. I mean, they've added a lot more provisions, it appears.
They added provisions in certain areas. It's a fairly in-depth program. It has a lot of accountability. They didn't change any of that. The cities, the participants have to report to the cities each year, and the cities are supposed to report to Commerce. That wasn't changed at all. They did, like I said, kind of update, I guess we would say, the expiration date, the wages from 18 to 23, and also added quite a bit of, I think the biggest changes were in the area of where preference would be given for certain types of businesses. Those weren't in the original statute, but they are in the current bill that is before the governor now.
Okay, great. Those are my only questions and comments. Any of the other commissioners? Okay, but we'll hear the full report again. My understanding is in the future, correct?
You'll probably hear it again in August. I think that Keenan can voice on that. He has the call, but I'm always willing to talk about it.
We can do it even more times if you would all like, but we'll definitely we'll keep it with the full set of reviews in August so that everybody knows it's still technically on the docket, and it's still subject to testimony and commission comment in the later parts of the year as well.
Okay, great. Thank you.
Thank you.
Yeah, appreciate it. So with that, and I see that Stacia Holler is on the line. Do we want to jump back, Stacia, if you need a moment to gather yourself, or?
Well, we have one more item.
We do?
Sorry, on the legislative updates. Rachel Murata.
Oh, I'm sorry, Rachel.
And
sorry.
I'm here, so whenever works for you guys, just tell me.
Okay.
I'll be here.
Sorry,
the whole time.
I jumped the gun, Stacia, so I apologize. So
No problem.
yeah, go ahead, Keenan, with Rachel. And Rachel, I apologize.
Okay,
ahead,
this will
Rachel.
just take a second. We wanted to give you a quick update.
Mhm.
Good morning, Rachel Murata, staff to JLARC. We just wanted to give you a quick update on the status of recommendations on the property tax exemption for multifamily housing. Just to refresh your memory real quick, you may recall back in 2019, we published a report on that property tax exemption. The legislative auditor made 3 recommendations to the legislature, the Department of Commerce, and the Department of Revenue. Those related to issues with the income and rent limits for affordable housing, as well as the reporting detail and compliance with the reporting requirements. You endorsed those recommendations and added more detail, including the idea to set up a work group in light of some disagreement from the agencies as to some parts of our recommendation. As you may remember, in 2020, the legislature considered several bills that would have implemented the legislative auditor's recommendations and yours in various ways. Ultimately, it did not reach agreement on those provisions, but it did pass a bill that would have created a work group as you recommended. That provision was vetoed along with a number of other new spending provisions after the pandemic decreased state revenues. This year, a bill was introduced that was similar to some of those that were considered in 2020, but included new provisions that were the result of stakeholder work that was done over the interim. That bill passed the legislature and was signed by the governor on Monday. So as it passed, that bill has some provisions that implement the spirit of the legislative auditor's recommendations and yours, if not the letter of them. So to give a few examples, the bill requires annual reporting to include metrics like household size, which will enable more analysis on affordability in the future. It provides for cities to base their affordable rent limits on the median income in their own city. It prohibits cities from offering exemptions when they are out of compliance with the reporting requirements. And it requires the Department of Commerce to ensure that properties are being audited for compliance with the income and rent limits for affordable housing.
I'm actually impressed. That's actually some pretty big changes to what was originally in that bill in terms of the tax preference, in terms of responsibilities on reporting. Because as I recall, that was a big issue for staff, is finding any information from anybody who'd filed reports at all.
That's right.
Okay, that's great news, actually. Any questions about that from commissioners? Okay, not seeing any. Thank you, Rachel, for that update. Okay, now let's hope I'm reading this right. So we are now able to skip back to Stacia. Is that correct? Okay. Okay, Stacia, if you could come on and give us your review of complying with public meetings and public records, that would be great.
Good morning, members of the commission. I appreciate very much you accommodating my schedule this morning. I apologize for not being able to be here right at 10. My name is Stacia Haller. I'm a Senior Assistant Attorney General, serving as legal counsel to the Tax Commission for a number of years now. This is, I think one of these years what I'm going to just do is have you guys give it back to me, because you've heard from me so many times now that I pray not to do this. But I appreciate the seriousness with which you look at these issues, and the fact you do give me this opportunity each year to come back and talk with you briefly about these issues. First off, I'd report there were no legislative changes to these laws on this go around, so there's not really anything new. As well as the fact that, unfortunately, we still find ourselves in the virtual world here. Fortunately, or unfortunately for the reasons, I think there's been some advantages to the virtual world. But so all the those provisions are all pretty much the same in terms of how we conduct the meetings. So I am just going to go over a couple points on both open public meetings and public records, just brief reminders for you. So again, turning first to public meetings, basic rule is if you have more than a quorum, which in your case is 3 people, wherever 3 shall meet, it shall be a public meeting. If you are discussing business, Of course, you guys all know my favorite example is if you're getting together to talk about my favorite basketball team, then that is not, the business of the commission, and therefore that would not be subject. But as long as you're talking anything that relates to the commission business, you have to be cognizant of gatherings. It's nice. I don't ever have to worry about breaks anymore, right? Because we're not in the same room. So the type of situations that might have arisen in the past really are an issues, unfortunately, right now. But there are a couple other areas you just do want to be sensitive to is emails. The courts have deemed that email could constitute a meeting. So that's why you will always see, you have, as you know, wonderful staff with JLARC, and they're very good about kind of reminding you each time, please don't reply all to emails because that can constitute a meeting. A conference call, a Zoom gathering, any of these things could be a meeting. So just be cognizant of that. The other issue are regular versus special meetings. And if I'm recalling correctly, I think we might have had a special meeting last go around, right? It's not a normal occurrence for this group, but it can happen. And one of the law is a little different, mainly about how you notice the meetings and then what you can talk about at the meetings. So your regular scheduled meetings are the ones that are set well in advance. The schedule's all set. A special meeting is when something comes up between those regular meetings or some reason you need to meet on a different basis. In that case, 24 hours notice has to be given. And that's all taken care of by staff. So I'm not really going to focus on that. But the main difference is on the when you meet in a special meeting, you may only take action on those items that were specifically set forth in your agenda, and the agenda has to be published in advance. That's really the biggest distinction. And so you just need to make sure that if you have something you want to accomplish in a special meeting, which is normally a situation, it's usually called for just limited reasons, that those reasons are stated on the agenda, and you stick to only taking action on those items. And don't worry, if that happens, I'll be there to help keep you on track. Executive session's really not been an issue with this group, and there's a reason for that. You can only do them under very specified circumstances that are set forth in the statute, and most of those circumstances are not ones that are likely to come up for this board. I have represented many different types of commissions and boards over my career, and some have this come up probably every meeting. And in the executive session, the idea there is that the public is excluded from those meetings. Board staff who are necessary and your lawyer, should they be necessary, can be present. But again, the only possible situation I see for you is if, hopefully never, but we're in the pending litigation or threatened litigation situation, or need to discuss something that would likely trigger litigation, then we can meet. And in those cases, the attorney, your counsel must be present for the purpose of actually providing legal advice, not just being there. Yeah. But let's hope we continue our run in that regard. If in terms of penalties, should there be a violation, any action that you would have taken at that meeting is deemed void, you can go back and take that same action again in a properly constituted meeting, and it would be fine, but it would be at void as of that time. You do individually as commissioners can face a penalty, civil penalty for knowing violation of the law, $500 for the first time, and a couple of years ago they added the additional, if it's a repeat violation, it goes up to $1,000, but those are still the current penalties. Really the big one, in all honesty, is cost and attorney's fees, because if a successful action were brought against the commission for violation in public meetings, the commission does end up paying the attorney's fees for the opposing party, and there are and the costs, and that's, we all know those dang lawyers are expensive and it can run up. So except for me, I'm not that expensive, but so that's kind of summary on public meetings. Are there any questions, any things that have come up, that anything new that you'd like me to address?
This is Grant, Stacia. So one of the, the whole legislature went through this more or less virtual session here recently. I mean, that had to have been a learning by doing exercise. Was there any issues that came out of that from the public, or things that surprised people that maybe was covered by the law but nobody thought about it? I mean,
Well, the first thing I'd say is that the legislature is not subject to the Open Public Meetings Act, so they don't as a body they are not subject to it, so it doesn't come up from that angle.
Okay. All right, fair enough. I had forgotten that actually.
Yeah.
Okay.
No, yeah. Let me say, I represent some groups that have some legislators on them, and they have learned that the law that they pass can provide some interesting challenges at times. It's been interesting.
Okay. Good.
I'll leave it at that.
No, that's a good reminder. I had actually forgotten about that.
Yeah. It's a great question, Grant, and I should say, as I'm first off, I was going to move into Public Records Act if no further, and I guess I would say that that's true to some level of the Public Records Act as well. It does apply legislature in some settings, but it's somewhat differently than for most agencies.
But just so I'm clear about this, so a group like us, we do have legislators that are non-voting members. So obviously that exemption doesn't extend to if you have a legislator on your group. That coverage doesn't apply. It's only specific to the legislature themselves.
Right. So right, exactly. Because I have another commission I represent that has four legislative members on it. So they are subject to the same OPMA requirements when they are acting in that capacity, as opposed to acting in their general. I apologize. I hate the fact that I have two screens, and so I mean to be looking at you. It doesn't always work right. Right. So exactly. Good. Yeah, that's a good question because it does come up and it can take some education. Public Records Act. A lot of this, again, is handled by your staff in terms of dealing with public records, but there are some things I want to quickly go over things and then just remind you of some things that are specific to your responsibilities. So basically, you start from the premise that any type of recording that addresses or is used in, possessed by, a public entity is going to be deemed a public record. But there's always kind of a two-prong. Is it a public record? And then actually three. Is it a public record? Do you have to retain it? And then upon request, do you have to provide it? It's three different steps, and people tend to mush those together. So I always like to really separate them. And all this, all the material I'm going over is, of course, in all the attachments that are in your materials. But so basically, just start with if it's something that comes into your possession as a result of your work on the commission, it's going to be a public record. Would be the premise I would start with. Then the next question is, how long do you have to retain the records? And again, for the most part, the reports, all the things that you get are handled by the staff, and they take care of the retention. The one thing that you are responsible, though, are your own meeting materials. So to the extent if you print out, materials that you get in your course of your work on the commission, and you then maybe take notes on them while people are talking, or however it is you use them. Those are public records, including your notes that are being written on there. And in terms of retention, this is an issue that I was pretty excited. I think we addressed very well a couple of years ago. I'm still proud of this one, in all honesty. Yeah, big shout out to Keenan and the staff of really taking this issue on. It's not specific that we have these state retention schedules, and it doesn't specifically address this type of situation, other than to say that these records must be kept as needed for essentially business purposes, whatever that is, and that can be deemed by the commission. And so that led to the commission adopting Commission Policy 1601 several years ago now, which basically talks about that once your report is issued at the end of each cycle, that then concludes the business use of any of those records that you had, and you are then no longer required to retain them. And I encourage you, not only are you not required, but it is in probably everyone's best interest that you don't retain past that period of time, because if you retain the record, even if you didn't have to, then it you still have to make sure you know where it is and can produce it and all those kinds of things. And that may not be that may be time that you don't want to have to be looking at things. So that's kind of the big one for the commission, is those materials that you're handling yourself. Once a couple exceptions to the destruction or main is if the commission were to receive a public records request, at that point all records are frozen, if you will. You can't delete something, or even if you could have under the retention policy otherwise. So you would be notified by staff, we have a public records request, please don't destroy anything, hang on to it until we figure out, is it responsive, do we need it, all those kinds of things. So that would be the one exception. I mean, there are some penalties that apply to just intentionally destroying public records, so you don't want to do it. It also can cause problems, obviously, if there's a request and something was destroyed in that process. But the big issues that can be for individuals like you, who this is not your day job, so to speak, being on these commissions, is the temptation to use personal equipment and things in your work, or the need to in some cases. As you all know, you have email addresses through the commission, and there's a really, really good reason for that, which is this whole area. And so please, very much encourage you to make sure that's what you're using for official business. If you are looking at commission documents or other things on your personal equipment, that is fine if all you're doing is looking at them. That doesn't really trigger anything. If you're saving them for some reason on a personal, onto your own PC or something like that, that does raise issues then. And I would highly encourage you, if you're doing that, I mean, hopefully, most of the time you don't need to, but if you do, make sure you're segregating those somehow into a file that is clearly for commission business, so that should there be a request for those records, they're segregated, they're easy to obtain, and it allows us a much better chance to fight off any kind of request to search your computer for records. If we can say, you can file an affidavit that says, here's where I kept them, here they are, we're all good, okay? And also watch for that text messages or public records, other things like that. So any questions? I want to stop there on this piece in particular, because this is the piece that I know may raise questions.
Stacia, this is Grant. You and I had a brief conversation about, so as chair, I sometimes have my JLARC life extends out through the legislative period where I have to give testimony to the committees. And you said it's best for me to wait until that testimony period is over with before my business is concluded and then can throw out those records. Is that different for the commissioners who are not doing that as the non-chair members?
I believe, I mean, if you knew whenever the report is, I lose track of time. Let's say August. We're right around there, right? If any of the other commissioners, there was an intent for them to testify, you'd already made those decisions. You knew it was all going to happen. I think in that case, it might be, to me, then it's more a question of, do you need your notes? Do you feel like you need your notes to do what you're going to be doing? Okay. And the reason I caution a little bit about it is, once the report is done, it's now the commission's report. It's not your notes or, those kind of things. So you want to make sure you're being kind of cautious about that if you are testifying, you're testifying about what the commission decided. But to the extent your notes help you along that regard, I think that would be fine. I don't think there would be a violation if you destroyed your notes and then it turns out you are testifying. I don't think that's a problem, because your policy says this is what it is, and you get to make that call. So it's kind of that, but I do really, really caution people to make sure that if you are speaking as on behalf of the commission, you're authorized to speak, and you're speaking on the commission's position, not your own personal commission. We had this come up recently with another commission, and you just got to make sure that you're clear what your role is at that point in time. Is that enough of a it depends answer to be a lawyer answer for you, Grant?
No, I think I just needed to make sure that we heard from you. It depends a little bit on what you're doing. Well, no, I mean, I think it's important that, if you're chair or you're acting in the chair's position, your window of retention is maybe a little bit different than other people on the commission who are not having that role.
Exactly. And I appreciate that for reminding me that we had that conversation and say that, And in this case, it's not the lawyer's waffling. It depends. It really is more of a practical, it depends, kind of situation.
Yep. Understand.
Okay. Great. Any other questions on that before I
Looks like
move on?
Commissioner Kyogo has a question.
Stacia, thank you so much for the presentation. I've been through a number of these orientations, and every time I get a different orientation. So I just want to clarify a couple of things. One, the way I understood it is if I get documentation from the team, and this is materials that I'll use during a meeting, I download and print some of those, scribble on those, we make a decision. I can put them in the trash bin once the commission's report goes out, correct?
Correct.
The second thing you said is we need to, and maybe I'm paraphrasing this incorrectly, but you said we need to be careful with where we save our materials. We've gotten an email, but to be clear, I'm working from home. I'm using my own personal PC, and I'm using my own personal hard drive to save some of these materials. I'm not amending them, but that's where I'm downloading to print them. So it's awkward when, I'm not sure this is something you can address, but it's awkward when we're told the language is that you're doing commission business, yet the commission hasn't given us the computing equipment to do its business. Right. So it's very different if this was my job and my employer provided me with a computer and I had computing equipment that I would use then for my job. This is a service that I'm doing to, my state, but I'm not being given the computing equipment that I can easily segregate out. So it's just a clarifying part of, if you are expecting folks to do this, then it is a little bit onerous to then say, oh, you need to be very careful with where you put this material, yet the only thing you've provided me is an email address. You've not given me a folder where I can save this material. You've not given me a device where I can use when I'm working on the commission's work. So a lot of us are working between our office computer, our home computer, our personal devices when we're doing commission work. And the language you're using seems to imply that we've been provided computing equipment. So I just wanted to...
Sure.
I'm not sure we can address that here, but that's the way it felt implied in the presentation you just made.
Okay, so thank you. Thank you so much for pointing out. It's very helpful for me to know how it's being heard. So let me try to address it a little bit, and then Keenan, feel free to jump in too. What I meant to be saying. So I'm going to use myself as an example, if I may, to let's go back 18, 19, however many months ago it was, before we all started working from home. I would work from home in the evenings a lot, like other people do. And at that point, I didn't have all my state equipment here at my house. I had my own PC, right? So I would email, I had a brief I had to review. I would email that brief to myself on my home address. I would then take that brief, and on my own personal computer, I had a file that said AGO business, in all my file lists. Anytime I was working on anything that was related to work, that was always where I put those documents when I would download them and keep them there. And I would work on them and alter them there and all that kind of stuff, and then email them back to the office. Long as I was doing that, then if there was a public records request that said, we want all documents that relate to X case, and that's the case I've been working on, I would be able to go to my personal computer, take everything off that one file, right? And provide it, and all would be good, and there would be no question about anybody needing to look at anything else. Earlier on, before we became sensitive to this issue, people were kind of like using their phones and just like stuff was everywhere. And there became some questions about, well, how do I know where, that I got everything if it was on your personal computer? And that's why we started the system of, if you keep it in one place, then it's easy to deal with, and you can just say, and nobody's going to, you just have to say, this is where I kept my work stuff on my personal computer. And if we should ever need to produce it, staff could do that. To the extent it's just copies without notes on it, that's probably not going to be an issue, but if you're making notes. So that's probably the best answer I can give you on that piece. I understand very much what you're raising about the equipment issue. Again, I represent a number of commissions that are along your type, where these are not people's day jobs. So that's the advice we provide to try and make it easiest. Does that clarify? I know it doesn't address your equipment issue.
It does. I think the way that the language that I understood it is from, you're doing commission work, therefore you should be using commission type equipment. And I'm looking at my desktop and I'm like, I didn't get any computer.
Right. And thank you.
I think it clarifies that aspect. I think one thing I would make as a suggestion is, this is not something I got out of the orientation binder I received at the start of my service, and I guess I'm the newest member. So making that a little bit more clear that if you are doing commission work, set up a separate folder, or use share, there's these SharePoints and all these cloud-based places where you can save a lot of these documents. So as you're setting up an email for a commissioner, then you should also set up a place for them to save and work from, such that they don't have to save it on their computer. I mean, now we can do that. And I think that would make for a better separation of our work, our home life, and then our service to our community. But thank you so much for clarifying on that. That's all my questions.
Yeah.
I had a question as well. Is there any sense as to whether we will get hard copies this year of the documents? Because in the past, I know for me, that helped me to keep the physical separation. I wasn't downloading and printing or viewing on my devices. I literally just had the binder and would take any notes there. And then it was very clear what was commission business and what is not. But I understand that may be a hardship now if people are not working in the office. So I just wondered if that's something that could be a possibility this cycle.
And you probably get into operational issues that are unfair for Stacia to have to address. So if the chair's okay, I'll jump in here too. If any of you would like hard copies, we can definitely arrange to do that if that would be helpful on this issue. Yeah, we can prepare that. Just warn you, you probably are already aware of this already. Warn you of a couple issues on that about length, right? About the volumes of things you'll be getting in the mail, and as long as you're aware of that. And then the other issue I would point out, more just for your help on understanding information, is just recall that our web-based reports, sometimes the printed versions might make some of the more interactive features of the web thing less apparent. So you don't want to miss out on still probably trying to view some of the stuff online, even if it helps you note taking, to go to a printed copy. So by all means, if any of the commissioners would like to get things mailed out to them in addition to the electronic things, just let us know and we'll find a way to accommodate that. And if I could, probably to jump to Commissioner Kyoko's note to question too, because it was kind of addressing some operational issues as well. We could definitely explore setting up some kind of SharePoint/cloud storage space for each of you as a commissioner, if you think that would facilitate making it a little bit more distinct, that when you're saving it, it's really, really clear it's not on your machine, because it would be in a separate environment. We've got great tech staff. I'm sure they could come up with an arrangement like that that would help. The other thing I know that I've heard of other individuals doing in similar organizations where they kind of really don't have the storage and computer equipment themselves is sometimes they will take any materials they've created and they'll email them back to themselves in their official email address and store it in a folder there as an attachment, because then it's always retained in the legislature's servers and it's not on your machine at that point. It is actually stored in the email system that way too. So a couple options there. So if any of those are of interest, please just get in touch with me and we'll make some arrangements for you.
Keenan, this is Grant. Yeah, I mean, I actually have some interest in this. Sharon's question was actually pretty timely, because as Stacia was talking about these issues, I was also thinking that, I have an iPad. That's my iPad, because I need to try to also keep it separate from my Vista work computer. So I'm in a weird position too. And on my iPad, the emails all go through a Microsoft app, which I put on my iPad to read the emails from you and the rest of the staff. And the question is, going back to the earlier point, is that have enough wall around it so it's not about my iPad versus just the application where all the emails are being kept out in the cloud someplace?
Yeah, I think Stacia probably knows the answer to this better, because I'm sure she's seen some direct experience on it.
So yeah, I believe the answer there is yes. When this issue was first arising, when people started using all the, it was kind of a mess. I will be honest. It was a mess. Luckily it was a mess, which meant there was litigation, which meant we got some direction from the courts. And this is one case where I think the direction from the courts was really actually very helpful and very favorable to being realistic about things, which doesn't always happen. And so now really, all you have to produce is an app. You have to sign a form saying, this is where I kept it and here it is, kind of thing. It used to be a lot more onerous. So the direct answer, for once I'll give one, is yes, I think that is sufficient. But I want to not scare anybody to thinking this is they're going to come searching in. That's just not the way it works. And I very much appreciate the discussion that just happened, because the law often is way behind the technology. And so ideas like the shared files or the clouds or all this kind of stuff, that's, we're still at paper and pens. And I mean, it takes a while to catch up. So I think those are wonderful ideas to try and address the practicalities of the situation, because we really want to make sure it doesn't become so onerous that people won't do it, because you're correct. And I appreciate this is a service. Thank you. Commissioner Kyoko, that's a great point. And almost all the groups I represent are people like you who are giving of their time. So we want to make sure it's not done in a way that makes it too onerous that people just don't feel like they can participate. So great discussion. It's great to have this, for me, to not just have it be me reciting things and that we feel like we're moving forward. So thank you very much.
Well, and on that, so both to Keenan and Stacia, so can we look into this issue of kind of a location, on the cloud, where we could maybe the commissioners could have some sort of identifiable, clear location, just so it's more, there are clear walls around what's commission and what's personal.
Definitely. Yeah.
Okay.
And I think you have that, I think you have that environment about the emails themselves, because
Mhm.
even if you're reading the emails
Mhm.
on this device, they're all running through the legislature's
Mhm.
network system. So they are segregated there in our system, and they're not, and are accessible there. So it would really
Well-
come into other files. And so we'll definitely look into a way to set up a storage location for the non-email items.
Yeah, and the other thing is, once in a while I will get something, through my personal email. Might be somebody contact me about commission business. It actually happens sometimes. Somebody inside my company might ask me about, hey, I noticed you guys are reviewing this. I will usually, I think I've always sent a copy of that to my legislative email.
Yeah.
So.
Okay.
Great practice to do that, yes.
And I can't remember if that was on my other sheet or I'm not finding it right now, but I think I mentioned that somewhere about, mailing stuff to the JLARC staff, or I think is a good way to keep that kind of situation. And I do want to clarify that if you're just like downloading something and printing it, that's not going to cause an issue. It's, because that's just what it is. It's really if you're adding something, changing the document somehow.
Yeah. In that case, that Stacia was referring to, you wouldn't have created a new document. You're
Right.
just printing it.
Same, right. So,
Okay.
anything else on that before I just have a couple more points, I think, I want to make sure I'm not taking up more of my fair share of time.
Commissioners, anything else?
So I
Okay.
I just want a couple of quick things on this then, which is just what to do if you get a public records request. And this Grant was Commissioner Forsyth was partially going there, or I thought it might be. A public records request, if it triggers, once it's received, it triggers certain timelines and certain various things that need to be done. So just, I want you to be cognizant if someone were to ask you, gee, I'd like a copy, you're at the grocery store, you're at the university, you're at your school, wherever. Mm-hmm. I would like a copy of something that the commission does. Please make sure you let JLARC staff know immediately, because that would be a public records request. The law does not require it to be in writing or in some kind of specific form. Staff can handle, actually responding to it, but it's just important that they know about those things right away, whether they be verbal or if you get an email or something. So I just want to remind everybody, be passing that information along. I can't already address reasonable search and things. That was kind of the whole issue. And then talking about producing records, just real quickly on this, because again, mainly handled by staff. We talked about everything being a public record and what needs to be retained, but then there's a question: if somebody asks for it, do you necessarily have to provide it? The general rule is yes, you are going to be, you do need to provide that record unless there's a specific exemption that's set forth in state law. About why that would not be. And probably the classic example, frankly, is attorney-client privilege. So on occasion, I have sent memos to the commissioners on a particular topic. If someone were to request that, that does fall under attorney-client privilege, which is recognized in under Public Records Act. It is your privilege, the commission's privilege. You could decide to waive it and produce that. But if you don't, then that record would not have to be produced. Those are the types of things. So if you have confidence, for JLARC, for the tax commission itself, you deal with a lot of confidential information. There, the staff does, and this is an issue Keenan and I've worked on over the years as well. If there's that information is confidential, it stays confidential in JLARC's hands. In the tax, JLARC's hands too, in tax commission's hand. And so that would be another situation where you might not produce something if it's, subject to some kind of exemption. But again, those are issues that will be worked out with staff. But I just kind of want to give you that basic grounding. I know that was quick. Are there any questions that prompts for anyone that I can address? Okay.
Well, and maybe I have one to prompt for the commission if it's okay, Chair Forsyth. Stacia, could you tell them about transitory messages, transitory records?
Thank you, Keenan. So there are certain records that don't need to be retained at all, and those are what we call transitory records, and those are things that really are just the kind of thing that probably if you stand next to somebody, you would just ask them like, "Do you have time to meet tomorrow? You know, what's a good time for me to call you?" You know, those kind of scheduling, kind of procedural, administrative type, just real those type of emails you don't have to be retained. They just fall kind of outside the whole situation, uh, and that can be true of text messages. That's another place where that transitory tends to come up a lot in these days, or instant messaging services. Like in our office, AG's office, we have a Jabber system where we can, those have to, gets to be used only for transitory because they disappear of their own, you know, at the end of the day, they're just gone. So those kind of things you don't have to worry about retaining, and that's, again, like a good use for text. Texting substantive discussions is not really a good idea because that does need to be retained, and then that gets more complex, right, in terms of how you do it, because I do not believe that they don't have phones, right? You don't have a specific JLARC phone, but those kind of things shouldn't be done on text anyway, so it really shouldn't be an issue for you. Is that, Keenan, where you wanted me to go, or was there something else?
Yeah, exactly. Right.
Okay.
So
Thank
the
you for
text
reminding me.
message you send to me saying I'm at the airport or I'm rebooting my machine to get into the meeting, don't worry, those, you don't have to retain those. You can get rid of them.
Okay. And I think the only last thing I just want to touch upon, just so you know, are the penalties, what happens. And these are penalties against the tax commission, not these, unlike public meetings where it's specific to you as a commissioner, these are to the entity. But if there were a public records request and for whatever reason documents were not provided and the court determined they should have been, it can be quite expensive. The court can impose up to $100 a day penalty for each day the record was unreasonably not provided, and this can, whether that's per page or per whole document, still remains to be seen. That's not really been fully adjudicated. But again, the more expensive part also is the attorney's fees and costs again. So but again, that's against the commission, not the entity, not the individuals. So I want to make sure that distinction's clear. So you can blame Keenan.
Or make Keenan pay is I have to come up with a check, right?
So that's I've included again this year some materials from, I probably should start off with that, from my the wonderful friends at the Municipal Research and Service Center, which services local governments but produces, I think, some of the best resource materials around. And this law is equally applicable to both state and local. So those are in there for your reference, as well as some website aspects. A couple of those were new or revised this year. So, but otherwise pretty much same as what we've done. Any other things I can assist with in this regard?
Anything else
Right.
from commissioners? Okay, I'm not seeing any other hands up. So with that, thank you, Stacia, for filling us in again about that. So,
Sure. And I'll be around for the remainder of the meeting, whatever's left. I'm here now. Thank you.
you bet. All right, so we've been going now for an hour and almost 15 minutes. I mean, I'll be honest, the chair needs like a short break, maybe about 3 or 4 minutes. And so if that's all right, Keenan, we'll can come back in about 3 or 4 minutes. Thank you. Okay, I'm just waiting for a few more people to return.
I'm back, but I know I'm not showing up.
You're coming in pretty clear, Ron, even if you can't have your video on. All right, it appears we are back. So we'll go ahead and get started again. But before we go on, that discussion on the records was actually quite good. I'm actually quite grateful for Sharon for asking that question, because actually, I think the answer, when I started on this in 2013, the answer to those questions had perhaps changed a bit. And so it was probably a good idea to ask that question and review it. And again, just to reiterate, staff can look into some of these issues and get back to us about that. So we're going to go ahead and move on to the next action item that's going to require a vote, but it's the review of schedule updates. There's been some changes to the review schedule, and staff is going to discuss that with the commissioners.
All right. I just wanted to confirm that the screen is sharing and that you can hear me.
Yes.
All right. That's a good start. All right. Good morning, commissioners. I'm Scott Hancock, a research analyst with JLARC. I'll be speaking to you today about some proposed changes to the 2022 tax preference review schedule. Immediately after me, my colleagues Zach Freeman and Pete Van Morsel will discuss the 2023 and 2024 schedule with you. So there are three changes that I'd like to speak with you about today. The first is a move of one study from the 2021 schedule to the 2022 schedule. This is for the nonprofit cancer treatment clinics and centers property tax exemption study. The second item is an addition of one study to the 2022 schedule. And as you'll see in my later discussion, these first two items are pretty intricately linked, which is why we're proposing to conduct them with one another. And the third item, which I won't be speaking in too much more detail about, these are just technical corrections. These are two studies which have actually previously been approved for review in 2022. But the scheduled document does not reflect that fact. So we just need to make a technical correction to fix that matter. So for our reason for the first proposed change is that the cancer center preference is, we believe, best reviewed in conjunction with the nonprofit hospital tax preference. And there's a few reasons for that. One, the statute requires a formal relationship between the nonprofit cancer treatment clinics and centers and a nonprofit hospital. Second, during the research that we have performed, the beneficiaries of this preference appear to function as extensions of the affiliated hospitals. For example, they have shared billing systems. They share charity care policies between the clinics, centers, and the hospitals. So patients of these facilities seem to experience these cancer treatment clinics and centers and the hospitals as perhaps one entity. Third, we also found that the largest beneficiary of the nonprofit cancer treatment clinic and center property tax exemption is in fact regulated by the Department of Health as a nonprofit hospital. And fourth, aside from the largest beneficiary that I just mentioned, we're unable to compare the charity care provided at these clinics and centers to the beneficiary savings of the preference. That's because the hospitals that are affiliated with these clinics and centers don't account for the charity care provision at the center and clinic level. It's aggregated up to the nonprofit hospital level. So there just isn't the data available to make the comparison between the beneficiary savings and the charity care provided at these individual facilities. So because we believe that the cancer treatment clinic and center preference is best reviewed with the nonprofit hospital preference, we're also proposing to add the nonprofit hospital property tax exemption to the 2022 schedule as well. In addition to that, there's been significant changes to healthcare policy since the previous nonprofit hospital report was done. That was last done in 2007. And in 2009, there was the passage of the Affordable Care Act. And here in Washington, there was an expansion of Medicaid provision. That has, one area where we've seen that effect is that the Department of Health has a annual charity care report it publishes. And since the passage of the Affordable Care Act, we've seen the provision of less charity care. And so it seems that there's a relationship between the charity care provided by these hospitals and the passage of the Affordable Care Act. And third, in 2018, there were significant changes to the statute that governs charity care provision by hospitals in Washington. So for all these reasons, we think it's a good idea to add the nonprofit hospital property tax exemption to the schedule in 2022 as well. I also wanted to show you the schedule as it would appear if you were to approve these proposed changes. This also includes the food processor preferential B&O rates that I mentioned in the first slide. And I believe you might have a copy of this in your materials as well. If you have any questions about these proposed changes for the 2022 schedule, I'm happy to answer them.
Sharon, I see your hand up.
Yes, I just want to clarify. So are we looking at the dairy product processors, B&O, and fruit vegetable processors? Are those included or not included in what we'll do this year? I was a little bit confused.
Those have been previously approved by the Commission for review in 2022.
Okay.
The document itself did not reflect that fact. So we'll be prompting you to vote to approve a document that reflects that fact.
And then the nonprofit hospitals and the nonprofit cancer treatment clinics are included. So again, to clarify, are we combining those two or we are moving one up? Again, I'm just a little bit confused on that one.
The nonprofit cancer treatment clinics and centers preference was originally scheduled for review in 2021, and we've conducted some of that work already. During the course of that work, we found just how closely related it was to the nonprofit hospitals. So one of the proposed changes we have before you is changing the scheduled publication date of that report from 2021 to 2022, so that that work can be continued in conjunction with a new review of the nonprofit hospital property tax exemption.
So we have the team preferences to go through then.
Correct.
All right, thank you.
Any other questions from commissioners? Okay, I'm not seeing any other in terms of raised hands or spoken voices. So with that, there's a second part to this discussion that looks at the 2023-2024 period. So with that, we'll go ahead and move on to that part of the discussion about changes to the schedule.
One second, getting set up here. Pete and I are gonna, so Scott's talking about changes to the 2022 schedule, and Pete and I are gonna talk about some work we did to review and update the 2023 and 2024 review schedules. So following guidance from the Commission to prioritize in-depth reviews on a smaller number of preferences, JLARC staff.
Zach, you want to make sure you introduce yourself? And
Sure. My name is Zach Freeman. Good morning. Chair Forsyth and members of the commission. And so I'm going to do the first couple of slides here about some of the work we did, and then Pete Van Morsel will discuss the actual updates to the review schedules. So following that guidance to prioritize in-depth review on a smaller number of preferences, JLARC staff are proposing changes to the 2023 and 2024 review schedules. These changes are based on criteria developed by JLARC staff and applied to over 70 preferences from the 2023-2024 review schedules, as well as some preferences that were not reviewed in prior years that we thought might make sense for these upcoming years. So we divided our criteria into 3 groups. First, we looked at potential reasons why we might remove a preference from the current schedule. For example, if there was a past JLARC review where there was no subsequent legislative action, and we determined that another review was unlikely to reach a different conclusion or provide new information to the legislature. If there are a limited number of beneficiaries to the point that we would not be able to disclose relevant information in the review. And if there are legislative exemptions to the performance statement and expiration date requirements, we consider that to be an indication that the legislature may consider the preference to be of a more structural nature. And so these are some of the reasons why we might remove a preference from the existing schedules. But then we also looked at reasons to add preferences to that schedule. So if there is a specific legislative mandate for JLARC to review it, if there is a stated and measurable objective, which would lead to a more kind of insightful review, if the preference is set to expire basically 2 years from the review year, so that we would give the legislature 2 legislative cycles in order to act on any potential recommendations. If there is data available and a potential method to conduct a review. And then finally, we spoke to our colleagues from the House and Senate fiscal committees to see if they had any preferences that they thought would be of interest or that they knew that members were interested in. And so these were some of the criteria we used to either keep a preference on the existing schedule or add one to it. And then finally, there was kind of another category where we also looked at legislative history. So maybe there had been recent changes to either the preference or to the industry that it's in that would make another review or new review provide more valuable. And then we also looked at industry groupings. And so statute directs the commission to consider industry groupings, and by grouping preferences of the same industry, it also provides efficiencies to both staff and to industry stakeholders. And so these were the criteria we used, and we did scoping analysis on the preferences to kind of see if we thought they would make for a good review. And Pete will now go through the actual changes that we are proposing to the 2023 and 2024 review schedules.
Hi, good morning, Chair Forsyth, members of the commission. I'm Pete Van Morsel, and I'm staff to the commission and to JLARC. And as Zach just described, the criteria for our scoping review, I will be going over the proposed changes to the 2023 and 2024 schedule based on those criteria. For 2023, we propose moving 15 preferences from the 2023 full review schedule. This includes moving 14 preferences to expedited review. Among these are 3 preferences that had fewer than 3 beneficiaries and about which we would likely not be able to disclose much information. There is 1 preference that was previously reviewed by JLARC and for which a new review is unlikely to come up with a new conclusion. And 10 preferences for which we, in our preliminary scoping, found no stated measurable outcome that was likely to yield any actionable recommendations, or preferences that are likely of a more structural nature, and therefore we proposed not doing a full review for those. The change to the 2023 proposed schedule also includes moving the battery-powered electric vessels preference to a later year, specifically 2028. This preference was initially on the 2023 schedule, but in 2020, legislation extended its expiration date to 2030. Therefore, based on the expiration date criterion, we propose moving this off of the 2023 schedule. And if the commission approves those changes, JLARC staff recommend instead doing a full review of 8 alternative fuel-related tax preferences. This includes the preference for zero emissions buses, which is currently already on the 2023 schedule due to its 2025 expiration date. We propose reviewing together with that a group of related preferences that were all enacted or extended in 2019, along with the same tax preference performance statement, which was to increase the use of alternative fuel vehicles in Washington. We also propose reviewing the warehoused agricultural crop protection products tax preference. This preference expires January 1, 2026. And because of that, we're reviewing it in 2023 rather than its currently scheduled 2024, would give the legislature 2 sessions to respond to any legislative auditor recommendations. We also propose moving the historic property tax exemption from the alternates in 2023 to a full review. This preference is has a performance statement and a stated measurable objective that we could evaluate. And we propose grouping that together with the historic vessels property tax exemption. It doesn't have the same policy objective, but it's a related, it's a preference with a related purpose and a related operation. We also propose adding the rural county and CEZ new jobs business and occupation tax credit. We propose moving that from the alternate list to the full review list. And this was last reviewed more than 10 years ago. We propose revisiting this preference with to see if new analytical approaches could shed more light on use of this and success of this preference. We also propose grouping it together with the international services B&O tax credit. This is a smaller tax preference, but it does function in much the same way that the rural county and CEZ new jobs credit does. So we propose reviewing these 2 B&O tax credits together.
Sorry, Pete, real quick, could you remind me what CEZ stands for?
Yes, a community empowerment zone, if I'm not mistaken. And okay. These are specific geographies within which the beneficiaries have to be located.
Okay, I could not remember off the top of my head what that stood for, so thank you.
And so if the commission does approve these proposed changes, the 2023 full review schedule would look like this. And I apologize for dropping the index numbers on the left side of this table off. They are included on the table in your memo. And so there are a total of 14 preferences on the 2023 full review schedule as proposed. If you have any questions about these, I'd be happy to try and answer them, or I could move on to 2024.
So, any questions from commissioners on this change? And I'm sorry, I can't see everybody's pictures, so if you do.
I'll ask a quick question.
Okay.
So it's 14 for full review and another 14 for expedited review?
Commissioner, there would be more than just those 14 on the expedited review. The expedited review schedule would include all of the other preferences that are not subject to full review. So it would be those preferences that are currently already on the expedited review schedule, plus those 14.
Okay.
Less those that we would be moving up to full review. So
so the math kind of changes every year.
Yes, it depends on what you elect to place on the full review schedule and whether things get moved to other years. But we don't depict everything on the proposed expedited review schedule in the slide or in the memo. We mostly just point out the full review schedule and those items that we propose to take off the full review schedule for simplicity.
Okay. Still getting my sea legs, so commissioners, please bear with me.
So just a comment from me about these, just real briefly. I do like this change to the extent that you have a bunch of similar preferences that you can group together. And they're all within the policy realm that I think is of great interest to the legislature at this time. So there is some rationale for the, especially for the alternative fuel stuff. I think it looks pretty good from that point of view.
So if there are no further questions, I'll discuss just the next year, 2024. The changes we propose to the 2024 schedule include moving 3 preferences to 2023, which we've just discussed. So I'll just briefly mention those. These include 2 alternative fuel commercial vehicles preferences, and those would be grouped with the zero emissions buses and other alternative fuel preferences. And also the warehoused agricultural crop protection products preference that we propose to move up 1 year because of its expiration date. We also propose moving the entity-owned non-resident vessels tax preference off of the 2024 schedule. Prior to the legislative session that just ended, the review of this preference was mandated to be performed in 2024. However, legislation passed this session to expand this preference and extend it, and also move JLARC's review to 2028. So we propose to make a change to the schedule to reflect that.
Peter, when you say entity owned, are these like cargo vessels?
Commissioner, no, they're not. They are, the definition of entity owned, it's essentially, it includes charters, private boat charters, and this is an economic development preference. And the definition of entity owned is it's not cargo vessels.
Okay, that makes sense.
We also recommend moving 4 preferences to expedited review. That table of the changes to the 4 preferences we moved to expedited review is included in your memo as well. And these are also preferences with one of which is expired, one of which has no current beneficiary savings, and 2 other preferences without stated measurable objectives. And if you approve those 8 changes, staff recommend in place of those, reviewing a billing discounts public utility tax credit in 2024. And this is a credit against the B&O tax for discounts that utilities provide to low-income customers. This was previously a 2023 alternate, but we think a full review could provide insight into the working of this credit, and there is data available that we can analyze. We propose reviewing 4 interstate commercial transportation preferences that were previously reviewed in 2010. At the time, JLARC staff and the legislative auditor recommended repealing 2 of these because they previously existed to comply with the Constitution. That was no longer required, but at the time, the Commission did not endorse that recommendation, recommending instead that a study of economic impact of the termination of these preferences be performed, namely a study on the impact of the industry competitiveness and on tax revenue. The Commission proposed that the legislature require such a study. The legislature did not, and at that point, the Commission stated its intent to determine whether to do a full review of its own, to schedule this for a full review. We propose to do such a review now. And with our acquisition of the REMI economic development, economic software, we believe that we could add some value to that study now. We also propose reviewing 8 aluminum-related tax preferences. These are currently on the 2025 schedule, but some of these expire January 1, 2027. So to give the legislature 2 legislative sessions for implementation of any recommendations, we propose moving this to 2024. And finally, we recommend adding 2 precious metals and bullion tax preferences. We recommend reviewing these a second time. Since their initial review in 2012, there have been changes in economic nexus requirements that may have contributed to a shift in the composition of claims and the composition of beneficiaries. There are more businesses registered out of state that are now reporting taking this deduction. And more claims have been occurring in the retailing portion of the exemption than in the wholesaling portion of the exemption. Finally, there's been some legislative interest in this preference with several repeal bills that have been introduced in recent years. And so if you do approve those changes, this would be the look of the 2024 full review schedule. And it is a longer list of preferences than the 2023 schedule. I did want to point out that that's because it includes the 9 preferences for the aerospace review that you previously heard in 2019. We anticipate, again, grouping those together as one review. And again, this is mandated by the legislature to be reviewed by JLARC every 5 years. So it seems like not that long ago you heard this, and 2024 is coming up again. This also includes a list of the 8 aluminum preferences that I mentioned. So that would be one review. Given those groupings, this long list of preferences would actually result in fewer individual tax preference review reports than the list indicates.
Yeah, but this is the chair, but I mean, so you can group them together, but does that, I mean, on the surface, this looks like a heavy lift for JLARC, but I'm assuming you have thought about this and know that you can do this.
Commissioner, yeah, Mr. Chair, yes, that's right. We do think that this falls within, that we have the capacity to perform these reviews. In particular, the aerospace tax preference reviews. One of those included in the list is the aerospace, commercial airplane manufacturing preferential rate. That's the second item on the list. It's included here, even though it's currently not effective. You'll recall in 2020, this preference was repealed as part of the bill to comply with the WTO ruling. There exist conditions under which it could be restored, but those conditions are not currently met. So it's on the list. It's the biggest component of the aerospace tax preference package, but not currently able to be claimed. There were also components of that review in 2019 that we anticipate not repeating in 2019. And so we wanted to make sure that while that's listed, we anticipate that this might not be the same intensity of a review as in 2019.
Okay. Questions from commissioners? Okay, not seeing any. So with that, we do need to vote on this. And so again, I'll go ahead and move, seeing no discussion, I move that we approve the review schedule changes for the 2022-2024 period. Do I have a second?
Second.
Hey, seconded. Thank you, Ron. So with that, I will turn it to JLARC staff to conduct a roll call of votes.
This is this roll call vote is to approve the 2022 schedule update and the 2023 to 2024 proposed schedule revisions. Ron Buing.
Approve.
Diane Lords-Dick.
Approve.
Grant Forsythe.
I approve.
Sharon Kyoko.
Approve.
And Andy Knopfinger Meadows.
Approve.
Thank you. That's 5 ayes and the motion is approved.
All right. Thank you. Okay. So we can now move on to the next and what is the last action item of the day, which is to approve the testimony questions for 2021. Just recall, these are the questions we encourage people to look at to try to focus their testimony. We take a look at these questions each year to see if we want any changes to them. So I believe staff will put those up for us. They are. Okay. So just glancing at those, do commissioners have any comments about these questions this year? Okay. Okay, not hearing any. Oops, 1 second here. There you go. So not hearing any, I will go ahead and move that we approve the
Commissioner
testimony.
Forsyth, sorry
Yes.
to step in. I
That's okay,
apologize,
Stacia.
but best practice would be to ask for someone else to make the motion and then have a second as opposed to the chair doing it.
Well, that's interesting, Stacia. Let me ask you a clarification about that. So when we started this process, one of the questions I asked is that okay for me to make the motion? And the response was yes. And so what you're saying now is that perhaps has changed.
That's again, it's not an absolute, but that has become the approach.
Okay.
So again, I hesitate to step in, but I just did want to share that information.
And
Okay, well,
that'll err on my part, Grant, of not further consulting a more knowledgeable party like Stacia than myself. So.
Okay, that's fine. I will go ahead and do that. I'll ask for a motion. The original purpose was to keep things as fluid as possible and making sure that I wasn't undoing Robert's Rules of Orders. So with that, okay, I'm looking for a motion to approve the testimony questions for 2021.
So
Move
moved.
to approve.
Okay,
I'll second.
okay, when we have a second. Okay, with that, JLARC staff will conduct the roll call of votes.
This is a roll call vote to approve the motion to accept the proposed 2021 testimony questions. Ron Buing,
Oh, approve.
Diane Lords-Dick,
Approve.
Grant Forsyth,
Approve.
Sharon Kilco,
Approve.
Andy Knopfinger Meadows.
Aye.
Thank you. That's 5 ayes and motion is approved.
All right, thank you. So I believe that's the last action item of today. So the last issue we need to discuss is the expedited preference review report, which I did look at. And looking at this report, there was a reminder me to disclose, and this is also a good reminder to the commissioners that periodically we need to disclose if we have some connection to a preference. In particular, there are a lot of preferences in the expedited list connected to energy use. I work for an investor-owned regulated utility. We supply electricity and natural gas. Some of those preferences may in fact touch the business and the industry that I'm in. Also, I should also disclose some of the preferences may also touch manufacturing, production kind of businesses or other businesses that may be represented by the Association of Washington Businesses, which is an association of businesses located in Washington State. I was asked to serve on a committee of economic advisors to that group. The company asked me to serve, so I'm just disclosing the fact that there could be some connection there as well.
And I've done taxes for years and years of specializing in the Washington excise tax area. And there may be a few of the preferences on which I have not done work for a client. But most likely you can assume that almost every single other one of them I have probably dealt with at one point in time in a client capacity.
Anybody else? And you know, going forward, I mean, I'm probably the person that has to disclose the most simply because utilities touch so many different things. But again, just a reminder to commissioners that, you know, don't hesitate if you need to. It's, you know, it's part of the process of serving on the commission. Any questions about the expedited reviews? Okay, I looked through them. I have none. I see none from other commissioners. Okay, so not seeing any, we're coming to the end here. I do need to just remind everybody that's on today that might be participating, but it's not a commission member or staff member, that anybody wishing to provide public testimony can provide written comments to Jay Lark, okay? Or they can mail them in at P.O. Box 40910, Olympia, Washington, zip code 98504. But the easiest way is really go to either the Jay Lark or commission website and get the appropriate contact information and submit testimony that way. So with that, do we have any other questions, concerns, comments from commissioners? Okay, not seeing any. Do we have any other issues from staff?
No, I just appreciate the commissioners' patience with all the lengthy information from today. I know it's a lot to go through all at once, but if there's any other questions that occur to you later, just feel free to get in touch with me and we'll be glad to help. And recall, we're convening again in August.
So again, thank you for staff for setting this meeting up, getting us all hooked in. And so seeing no further questions or concerns, I will call this meeting adjourned. Thank you very much, everybody.